Asylum status is a form of humanitarian protection offered by the United States. Eligibility of asylum application. Every year, thousands of people come to the United States from different regions of the world seeking protection from persecution. According to the US law, one can apply for asylum if they have suffered persecution or fear that they will suffer persecution due to race, religion, nationality, membership in a particular social group, political opinion. Procedure of asylum application. You can file an asylum application if you are physically present in the United States and you are not a US citizen. There are two types of asylum application, affirmative and defensive. A non-citizen who is not currently in removal proceedings may apply for affirmative asylum through the USCIS. On the other hand, a person who is in removal proceedings may apply for asylum defensively by filing the application with an immigration court. From November 2022, affirmative applicants can file their asylum applications online. Asylum applicants can legally work in the U.S. while their application for asylum is still pending. Asylum applicants now can apply for employment authorization document online. Wherever the asylum seeker stays in the USA, Rajulo provides fast and accurate services with proper care. Rajulo, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.
Hello everyone, and welcome back to the weekly Sunday live session hosted by attorney Raju Mahajan and Associates. For today, I am your host, Isabella Rosario, and with me I have a very special guest, Mr. Raju Mahajan, who is our principal attorney. Mr. Mahajan, it is a great pleasure to have you here with us.
Thank you very much, Isabella. Thank you everyone who are watching show at this moment and who will watch our show in future in our YouTube, Facebook, LinkedIn, and other social media.
And I'm again welcoming all of the audience members to our live session. For today, we have a very important topic, and that topic is Violence Against Women Act. Today, we'll be hearing more about it in details through presentations, both visual and audio, by Mr. Mahajan. Mr. Mahajan, please.
Thank you very much. Yes, please show the... Yes. So in this video today, in this discussion, we will talk step-by-step guideline for VAWA self-petition. VAWA stands for Violence Against Women Act, but everybody must know that this law is not only applicable to violence against women, it is applicable to anybody who is suffering violence. It can be male, female, children, anybody. So a lot of time people ask me question, is it only applicable to women? Only women can apply for VAWA self-petition? The answer is no. Both male and children and women, all of them, they can apply for self-petition under VAWA. Next slide, please. Okay, so the first question is what you have to prove to be eligible to apply for VAWA. And here I have, I'm going to show you like a 5 criteria, but you do not need to meet all 5. If you just qualify for one of these 5, you can apply for VAWA self-petition. Number 1, you are currently married to a US citizen or lawful permanent resident who is abusive. And here, I want to tell one more information, which is a very vital information. You can only apply for VAWA self-petition if your abuser is a US citizen or permanent resident, meaning that person has green card. If you are a spouse of an international student or H-1B worker or O1, L1, all kind of non-immigrant status holder, you cannot take benefit of this application. You cannot apply for VAWA self-petition. Again, you can only apply for VAWA self-petition if your abuser, husband or wife, is a US citizen or permanent resident, meaning green card holder. The next one is you have got divorced from your US citizen or lawful permanent resident spouse within the past 2 years. So either you are married right now with your abuser, or you have been divorced for within last 2 years. If it is more than 2 years, you can still apply, but that would cause like a more problem, and you have to establish why you did not apply within 2 years. So remember, you have to apply within 2 years of this this abuse and neglect happened. The third one is you married your US citizen or lawful permanent resident spouse believing he was unmarried, but later found that he was already married. According to American law, one person cannot be married to multiple persons. Therefore, if you marry somebody who was already been married, then you can also apply for VAWA self-petition. And here I want to say a little bit about this marriage, like it's a family law issue. I'm not going that deep into family law issue. A lot of time, husband and wife, they get divorced. Both of them know that they have been divorced. However, according to law, they are not divorced yet. So if you know that you're going to marry somebody who was married before, you must make sure that his or her previous marriage has been ended, the divorce has been completed. Otherwise, your new marriage, the marriage you're going to do, it's not a valid marriage, but you can apply for VAWA petition. So it's like if you do not know, then you can definitely apply for VAWA self petition. It has some benefit, definitely. Next slide, please. You married to a US citizen spouse who died within the past 2 years. See, there is no permanent resident. If you are married to a US citizen spouse who died within past 2 years, you also qualify for VAWA self-petition. However, if your spouse was a permanent resident who died within last 2 years, then you do not qualify for VAWA self-petition. The last one, you married to your US citizen or lawful permanent resident spouse, but she lost her immigration status within the past 2 years due to domestic violence. So this is another category. Your spouse, either permanent resident or citizen, lost his status, immigration status, because of domestic violence. Then you also qualify for VAWA self-petition. So these are the 5 categories. If you qualify just one of those, then you can apply for VAWA self-petition. So you must remember this requirement. Next slide, please. If you qualify for any of these criteria, now you have to prove to the USCIS that your marriage was in good faith, aka bona fide marriage. So again, bona fide marriage is also like a very important thing in any kind of marriage-based application. Bona fide marriage means it was in good faith. You married this person for the purpose of being, live together and staying together forever, having a family, raise kids, kind of that intent, not for any immigration benefit or any other kind of benefits. So a lot of time for a lot of family-based application, especially marriage-based application, you have to establish that your marriage with this US citizen or permanent resident was a bona fide marriage. And this is a legal term. Please remember this thing. Next slide, please. All right, now we're going to talk about step-by-step guideline. So VAWA self-petition has 2 steps. The first one is called I-360, and the second one is called I-485. In I-360 application, you have to establish all the requirements of VAWA, meaning you have been abused physically or mentally by your US citizen or permanent resident spouse, or children, or any relationship. Once it is established that you are qualified for VAWA application, then you go for I-485 application. Next slide, please. All right, so this is a very important piece of information. If you are the spouse of a US citizen, you can combine these 2 steps together. One I-360 and one I-485 together. It is called concurrently. You can also apply for semi-concurrently, meaning you are submitting your I-360 today, and then after like 1 or 2 months, you're submitting your I-485. So if your spouse is a US citizen, then you can either apply for concurrently, semi-concurrently, or one after another. That is okay. However, if your spouse is a permanent resident, meaning if your spouse has green card, then in most of the time, you cannot apply I-360 and I-485 together, meaning concurrently. You cannot do that. You have to follow visa bulletin. Again, I'm not going that detail into visa bulletin. That is a totally different discussion. Visa bulletin is very important. I advise all of you to know how to read the visa bulletin, follow Department of State website for visa bulletin thing. But the short point here is, if your spouse is a permanent resident, then when you will be able to apply for I-485 depends on the visa bulletin. If it is current at this moment, then you can apply those together, I-360 and I-485 together. If it is not current, then you have to get your I-360 approved. In your I-360 application, you will get a priority date. You have to check when your priority date is current in visa bulletin. Only then you will be able to apply for I-485. So please remember this distinction between whether you have a US citizen spouse or a permanent resident spouse. Next slide, please. All right, so now step one, I-360. In the first step, I-360, of course, you have to fill up the form I-360. It's a very self-descriptive form. You can, when you read it, you can fill it up by yourself. But if you need expert opinion, I advise you to contact a expert immigration attorney. Also, every form of USCIS has a instruction form. So every form has a instruction that you can download from your USCIS website. Those instructions are very easy to understand. Also, there's a lot of YouTube video and other places. So I know it's not that very hard, but again, I advise everybody to take help from expert immigration attorney because they know a lot of things. With this form I-360, you have to submit few documents. There is no fixed number of documents. Try your best to submit as much document as you can. Like number one, a declaration describing your relationship, the abuse you suffered, your good moral character, and anything else relevant to providing your eligibility. Write a declaration, like a statement, and try, if possible, submit it with a notarized version. So take it to a notary public, sign in front of the notary public, and submit that notarized copy to USCIS with I-360 form. Other evidence of the abuse, such as police or hospital record or court-issued protective order, this is also very important. I advise my clients to get a police report and hospital record. It is really, really helpful to get your I-360 approved. Office clearance record, sorry, there should be a P, it was my mistake. The police clearance record showing your criminal record or lack thereof. You can obtain the certificates from the police department of any town you have lived in during the last 3 years or more than 6 months. So you have to prove that you are in good moral character. You do not have any criminal record or any other kind of bad thing in your background. So to prove that, you have to get police clearance report. Any place you lived for more than 6 months, you have to contact the local city police department and request a police clearance report. They have online system. There's like a fee, I don't know, like $50, $100, kind of depending on city. Apply for that, get a copy, and submit with your I-360 application. Next slide, please. Also, prove that the abuser is a US citizen or green card holder. This is very important because, as I said in the beginning, to qualify for a VAWA petition, your abusive spouse must be a US citizen or green card holder. So you have to establish, if you do not have any document that he is a US citizen or permanent resident, you can submit a sworn affidavit saying that I know that he's a citizen, or I know that he's a permanent resident, and you have to submit a notarized copy, but you have to submit at least some kind of document. Then prove that you are the abuser's spouse, child, or parent, marriage or birth certificate. So you have to submit the marriage certificate or birth certificate or any kind of document. Prove that you lived with the abuser and you currently live in the US. Remember, to apply for a VAWA petition, you must be in the US and you must have lived with this person for at least some time. Next one is include a cover letter on top of the application describing how you meet each other. Requirement and the evidence you have submitted to prove it. File the VAWA petition with the Vermont Service Center. So again, the service center may change. Always follow the latest guideline from USCIS website. Service center may change, form may change, required document may change. Immigration things keep changing all the time. So please pay attention to all the latest changes and follow the latest guideline. Next slide, please. So this is a very special note. USCIS will not interview the petitioner about his/her VAWA self-petition, and there is no court date. So the petitioner will not have to testify about the abuse. USCIS will decide whether to grant your self-petition based on the written evidence submitted. This is why it is very important to provide sufficient evidence. Since there is no interview, there is no court hearing, there is nothing later that you can establish more. So try your best to submit as much information and document possible with your I-360 application, because later you will not get more chance to add anything. So this is a very important note. Next slide, please. All right, fee. There is no fee required to file I-360. This is a good thing. Currently, the fee to file for I-485, which is the second step, is $1,225. But the fee for Form I-485 can be waived if you satisfy some particular condition. Many of you already know that those who make less money, those who are not making enough money, U.S. government has provision that you may get your USCIS application fee waived. So there is requirement to do that. You have to fill up a form, submit your tax document with that. So if you qualify for that, you can also apply for I-485 fee waiver. It depends on your situation, but yes, if you qualify, why not you take the opportunity? Next slide, please. All right, now we come to step number 2, I-485 application. I assume that you already have a approved I-360. Of course, you have to fill up the form I-485. Similarly, the form I-485 is also self-descriptive. It has a instruction how to fill it up. With this I-485 application, if you already have a I-360 approved, submit the copy of the approval. Also, 2 passport style photograph. If you are submitting USCIS fee, try your best to submit a money order or cashier's check. Personal check is not recommended. However, if you do not manage cashier's check or money order, then personal check or credit card information is also okay, but I do not recommend those things. A copy of a government issued photo identity document, for example, your driving license, passport, or any kind of photo ID. A copy of your birth certificate. If your country's birth certificate is not recognized as primary evidence by USCIS, then you have to submit other documents like your testimony from your friends and family about your birth. It is called birth affidavit, or any other kind of document like your school document, your church document, or any other kind of documents. But try to submit a birth certificate and some other documents. Documentation of your immigrant category currently filled, pending, or approved Form I-360. As I said, if you have approved I-360, you have to submit a copy. If it is pending, submit a copy of the pending or other kind of documents. Next slide, please. Thank you. Disposition on criminal charges, arrest or conviction, if applicable. A lot of things for I-485 depends on if it is applicable. If it is applicable, you have to submit it with your application. If it is not applicable, just skip that part. Form I-601, waiver of inadmissibility, if applicable. Again, I'm not going that detail into Form I-601, waiver of inadmissibility, because that is not the focus of our discussion today. Some other day, I will discuss about waiver of inadmissibility. Documentation regarding J1 and J2 exchange visitor status, if applicable. Again, if it is not applicable, just forget about that part. Form 508, waiver of diplomatic rights, privilege, exemption, and immunity, if applicable. Again, if not applicable, just forget about that part. Next slide, please. Thank you very much. This was a very short, informative discussion about VAWA self-petition. Again, in this live session, I try to give you like a very general idea about everything. I do not want to go deep. Also, this is not a legal advice, because legal advice requires a one-to-one discussion about a specific fact. The purpose of this video is just a general information only. So if you have any question about VAWA self-petition or anything, I'm happy to answer now.
Thank you so much, Mr. Mahajan, for that wonderful presentation. I'm sure that we have all learned a lot of things about the VAWA Act. In the meantime, we have had some questions already coming to us. The first question that has been submitted is from Mr. MD Hawk, and he asks, if anyone is terminated from school and not overstaying in this situation, can he apply for EB-3?
The short answer is yes, he can apply for EB-3. However, if you are terminated from school, I strongly recommend you to apply for reinstatement, because if you do not apply for reinstatement, you may lose your status. So yes, you can apply for EB3, but until you are applying I-485, which is the third step of EB3, you have to be in legal status in any way, either in F1 or B1, B2 or other kind of status. You have to maintain your status. So short answer to your question is yes, even if you are terminated from school, you can apply for EB3.
I hope that answers your question, Mr. Hawk. Another question that has been submitted by, again, Mr. Hawk is, any agricultural labor can go to the USA as a worker?
Yes, any kind of labor can come, either agriculture or non-agriculture. Everybody can come to America.
Thank you so much, Mr. Mahajan, for that answer. Mr. Kemra Joshi says, R1 visa discretion.
R1 is a visa for religious worker, but I do not understand your question. You said, sir, R1 visa discretion. I do not know. But we have a video about R1 visa in our YouTube channel. If you go to our YouTube channel, it's a very easy to understand video. I advise you to watch that video. And if you still have questions, you can reach out to us. We will answer your questions.
I hope that answers your question, Mr. Joshi. Another question we have received is from Mr. Mahmoud Rahman, and he asks, what is the safest way to change the status from F2 to F1 within the USA or by going back to the home country?
If you say safest, I would say within the USA. But again, it takes a long time to change from F2 to F1, so you may need to wait a little bit to start your school. However, this is the safest because anytime you go out of country, you try to re-enter, there can be some problem in the airport or some other situation. So if I say safest within America, but if you say fastest, then going back to your home country, or you can also go back to Canada or Mexico, apply for F1 visa there and get visa stamp and come back again. That's also another option. But safest is doing this from within America.
Thank you so much, Mr. Majan, for your response. I hope that answers your question, Mr. Rahman. Now, for all of those who are watching, we have already had some questions that have been sent to our email. So now I will be asking those questions, and hopefully we'll be getting a very good response to that. The first question comes from Mr. 𝗦𝘂𝘃𝗲, and he asks, I am interested to go to the USA by B1, B2 visa with my family and work towards the green card application. How can I sustain my living expenses while I'm in B1 visa in the USA?
It would be very hard for you to survive here in America with a B1 visa because B1 visa has some very restrictions. Number one, you cannot work anywhere in America legally with a B1, B2 visa. You have to change your status from B1, B2 to other kind of visa. So B1 visa is just a business visa. It's like a tourist visa kind of. You come to America to do some kind of business activity. Your maximum period to stay is 6 months, and within 6 months you have to leave America. You have to go back to your home country or other country. So if you have intention to stay in America with your family, B1 visa is not a good one. Also, if you apply for B1 or B2 visa, in the interview in embassy, if they ask about your future plan, please do not say that you have an intention to stay in America. That will violate the requirement of B1, B2 application because B1, B2 is a non-immigrant status. You have to say that you are going to America for some business or some visit purpose, and once it is done, you are coming back to your home country. You are telling me that's fine because I'm an attorney, but please do not say that to any embassy official. But short answer to your question, it would be hard for you to stay in America with a B1, B2 visa. You can come here, you have to change your status when you're here, and then you can stay. You can change to F1, which is a student visa, which is a good visa to stay in America for a long time. Also, there's a H1, O1, many other kind of option, but you cannot stay for a long time in B1 or B2 visa.
I hope that answers your question, Mr. Rahman. We have received another follow-up question from Mr. 𝗦𝘂𝘃𝗲 in the meantime, and he asks how far we can go to the USA as part of agriculture. In your law office, will there be help for us?
The short answer is yes, we help with any kind of immigration, but to come to America as a worker, any kind of worker, agricultural, non-agriculture, you have to find the employer here in America. So let's say you want to come to America as a agricultural worker, you can contact any farm owner here in America or any recruiting company. and either the farm owner or the recruiting company, if they want to sponsor you, if they want to apply for you, then you can apply. You cannot apply by yourself. So let's say you found a farm owner who wants to apply for you, and then you and your employer, please contact us. We will take the initiative step to process the application. But without any employer, we cannot help you, because for work visa, in most cases, it is the employer who is the sponsor, who is the applicant. You are not the applicant, you are the beneficiary. We can only help actual applicants.
I hope that answers your question, Mr. Hawk. We have received another question from our emails. So Mr. 𝗦𝘂𝗍𝘆 asks, my wife is staying in the USA through F1 visa. I'm living in South Africa for the last 10 years, but I have no resident card here. But I'm legally staying here. Now, my question is, what is the best option to go to my wife from South Africa to the USA? If I want to go through F2 visa, then should I have to face consular interview from Bangladesh or South Africa?
Yes, initially the best option to come to America as your wife's dependent, because she's here the F1, F2 is the best option in considering everything. And once you are in America as a F2 visa holder, then you can change your status from F2 to some other kind of visa. You can face the interview either in South Africa or in Bangladesh or pretty much anywhere in the world. There is no limitation in which consulate or which US embassy you have to face, but you have to face somewhere. So I think South Africa would be good for you since you already live there, but you can pretty much face anywhere.
Mr. Hassan also asks, can I work in the USA through a dependent visa? And he also asks, can I study for master's program while staying on F2 visa?
The answer to your first question is no, you cannot work legally when you are in F2 visa in America. You have to change your status to any kind of work visa. There are many work visas. One is H1B, one is O1, L1. There's many kind of work visas. So you have to change your status. Otherwise, you cannot work legally. The short answer to your second question is you can study while you are a F2 dependent, but it has to be a part-time status. You cannot study full-time. So the difference between part-time and full-time is if you register for more than 9 credits per semester, that's a full-time education. And if you register for 6 credits or less, that's a part-time education. So as a F2 dependent, you are qualified to study part-time. But if you want to study full-time, you have to change your status from F2 to F1. Also, there are some other benefits with F1. That's why a lot of people, they convert their F2 to F1. Number one, you'll be eligible to apply for OPT, CPT, and other kind of student visa related benefits. You are eligible to work 20 hours on campus as the F1 visa holder, but with F2, you are not eligible for any of those. So you can only study part-time as F2. So short answer to your question, yes, you can study, but it would be good for you if you change your status from F2 to F1.
Thank you so much for your response. Mr. Hassan has submitted 2 more questions. So he asks, how can I get permanent residency through F2 visa and how long it may take? The final question is, I am doing business in South Africa. What is the probability to get visit visa with my profile? I have no travel history except India and South Africa.
The answer to your first question is how to get green card from F2. It's a very broad and kind of vague question because it depends on your background, what you're qualified for. There are many options to get American green card. NIW is a good option, EB1, EB2, EB3, EB4, EB5. There's many options. So the question is which one is more applicable to you. But based on your information, I think EB3 would be a good option for you. Whether you are applying from South Africa or you are applying from America, either way, EB3 would be a good option. But again, I need more information. Answer to your second question is whether your profile is good enough for B1 or B2 visa. I think it is a good profile. You are doing business in South Africa. South Africa is a promising country. So your wife already lives in America. So I think B1, B2, or even F2 would be a good option for you to come to America. I think you are qualified.
I hope that answers all of your queries, Mr. Hassan. We have received another follow-up question from Mr. Hawk. He asks, regarding the agricultural question, what is the visa category?
there are many categories for agriculture. I think right now you can apply for EB3. EB3 is a green card application. Directly, you and your family will be eligible for green card. And if you get the visa, you come to America with green card. But there are some other temporary worker visas, but those are not applicable to Bangladesh. I'm assuming you're from Bangladesh. So right now, your best category would be EB3.
Another question from Ms. Raihana Akhtar, and she asks, "Hello, sir. I found an employer. Can you please help?"
Yes, if you find the employer, then you and your employer should contact us, and we can set up a meeting with your employer. If he or she has any question, I can answer those questions, and then we can start working. Yes, we can definitely help if you have an employer.
I hope that answers your queries, Ms. Akhtar. Returning back to the archive questions, we have some more questions from people who have reached out to us in our emails. And a person named Morshada Akhtar Moni asks, "If any American does my sponsorship for my study in the USA, then does this attempt facilitate to increase my visa chances?" And she also asks, "When can I apply for my spouse after getting my F1 visa?"
Can you please read the question again?
Of course. If any American does my sponsorship for my study in the USA, then does this attempt facilitate to increase my visa chances? The second question is, when can I apply for my spouse after getting my F1 visa?
The answer to your first question is yes. If any American person, especially the American citizen or permanent resident, sponsors your education here in America, that will definitely increase your chances of getting approved, because American embassy or consulate, they have chance to double check these people because they're already living in America, and that is good for everybody. It will definitely increase your chance. The answer to your second question, when you will be able to apply for your dependents, your spouse, for F2 visa, you can apply together. You can apply for F1 and F2 at the same time concurrently to US Embassy, and you both can have interview together and can get visa approval together and come together. That's a great thing. However, if you decide to come first and then apply for your spouse, you can also do that. Anytime you can apply for your spouse as a F2. There is no requirement.
I hope that answers your question, Ms. Moni. Another person has in the meantime reached out to us through our comments. Mr. Motiur Rahman Rani asks, "I have B1, B2 visa from Bangladesh. I will be going to the USA next month. Which is my next step for the green card process?"
Again, it depends on your background, it depends on your experience, your education, your financial status, many things. But short answer, many people are qualified for EB3 because EB3 has no special requirement. It's an unskilled visa. EB3 could be a good one. But also, if you qualify for NIW, EB1, EB2, EB3, EB4, EB5, or other kind of visa like H1B, O1, you can definitely try anything. I advise you to contact the experienced immigration attorney and discuss your background, and he or she, including me, we can help you.
I hope that answers your question, Mr. Rani. Another client in our emails have asked, Ms. Sonia Khan. She asks, "I was refused twice to get the Canadian student visa. The reason was that the Canadian embassy was not satisfied that I will leave Canada at the end of my stay and had lack of available financial capability to maintain myself and my family. However, I have IELTS score, which is overall 6.5. My question is that can I apply in the US for the student visa, although I have refusal from Canada? Is there any negative impact on this during my visa interview in the USA?"
No, there is no negative impact. Just because Canada refused their visa to you doesn't mean that US will refuse to you too. US, Canada, UK, Germany, you can apply for one country, get refused, and easily get visa from other country. It depends on their requirement. So one rejection has no impact on the other one. And I encourage you to apply for American student visa or other visa. However, one thing you said that you do not have enough financial backup to show that your study here in America would be financed by yourself. So, excuse me, I strongly encourage you to show enough bank balance in your account, you or your first blood, like your parents or siblings. Then apply for American student visa. That will help you. Otherwise, you may get rejected again from American embassy.
I hope that answers your queries, Ms. Khan. The final person from our archives is Mr. Shahid Hassan, and he asks, what are the initial documents I need to keep in hand to start the NIW process with you?
So can you read the question again?
Of course. What are the initial documents I need to keep in hand to start the NIW process with you?
So NIW is a long process. It's a long and big process. So I encourage you to go to our YouTube channel again, and we have a lot of videos, like 8 or 10 videos about NIW. If you watch all those videos, including everything, it may take like an hour or like a 90-minute kind of. You will get a very good idea about NIW. And but short answer to your question, you have to have a master's degree. And you have to have some good background, like a work experience or publication citation. Those are really helpful. So if you have that, you definitely have a good profile. However, again, I advise you to watch those videos because it's a long discussion.
I hope that answers your questions. So that is all we have, all the questions and the emails that we have for this session. Everybody, thank you so much for participating and for watching this session. We will be back again next week.
Hold on. I have some update about immigration.
Oh, yes, of course, Mr. Mahajan.
Yeah, no problem. Yeah, thank you. I'm going to tell you some latest immigration update. So many of you already know that the diversity visa lottery winners has been announced. So those who applied for DV lottery for last year, the winners has been announced. So please check if you are the winner. If you are the winner, you go ahead and move for the second step. But if you're not winner, you can apply again. But a short point here, not all countries in the world are eligible for DV lottery. Those countries are eligible, are mentioned in the USCIS website. So those who are interested about DV lottery, please go to USCIS website and see if your country is eligible right now. The second one is USCIS celebrates Public Service Recognition Week. So this is a celebration for all the people who work for American public service, especially for federal government. The week is from May 7 to 13. We also want to thank all the USCIS officials and court officials from our law firm. They are doing a tremendous job to help immigrants coming to America smoothly and legally. So I, from our law firm, thank all the USCIS officials and court officials. The next one is, many of you already know that last 1 week was very, there's like all the TV channels were like always busy about the Title II, things has been ended in May 11. So people are expecting that after this Title II entitlement ending in May 11, after that, the US border would be in huge crisis. But Biden administration was able to successfully manage it, and so far there is no major incident. However, I'm not going that detail about Title II because it's a legal thing. The short thing about Title 42 is because of the public safety ground, US government was able to deny some entry from southern border. That mandate has been ended. So right now the southern border is more immigrant friendly than before. Another news, a bipartisan group of senators introduced post-Title 42 immigration bill. Again, you'll see a lot of news like that, a bipartisan senator group, a bipartisan congressional group, Mr. X, Mr. Y is proposing something. Just because senators are proposing something doesn't mean this is a new law. These are just proposals. So we are not going to discuss anything until that is enforced. The last one is the US government drops COVID-19 vaccination record for foreign travelers. So those who are coming to America as a student or international visitor or some other categories, there were a requirement for COVID-19 vaccination record. That requirement has been ended, meaning now you can come to America without any vaccination record. Of course, getting vaccinated is very important, but now it's not mandatory for immigration in the airport or any kind of port. That was our weekly immigration update.
Thank you so much, Mr. Mahajan, for that update. I'm sure it was very informative for us all. Thank you so much, everyone, for watching and tuning in this week. Thank you, Mr. Mahajan, for giving us your time. We will meet again at the same time next week as well. Thank you, everybody, and have a great day.
Asylum status is a form of humanitarian protection offered by the United States. Eligibility of asylum application. Every year, thousands of people come to the United States from different regions of the world seeking protection from persecution. According to the US law, one can apply for asylum if they have suffered persecution or fear that they will suffer persecution due to race, religion, nationality, membership in a particular social group, political opinion. Procedure of asylum application. You can file an asylum application if you are physically present in the United States and you are not a US citizen. There are two types of asylum application: affirmative and defensive. A non-citizen who is not currently in removal proceedings may apply for affirmative asylum through the USCIS. On the other hand, a person who is in removal proceedings may apply for asylum defensively by filing the application with an immigration court. From November 2022, affirmative applicants can file their asylum applications online. Asylum applicants can legally work in the US while their application for asylum is still pending. Asylum applicants now can apply for employment authorization document online. Wherever the asylum seeker stays in the USA, Radulo provides fast and accurate services with proper care. Radulo, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.